As discussed earlier, the Constitution is the supreme law, the overarching law, the most law, for want of a better term, in South Africa. What this ultimately means is that we are a country of laws and that we are all bound by the rule of law. It means that there needs to be legality, it is written, it is common law, it is known, that there needs to be certainty with regards to the law, that the law needs to create mechanisms for the prevention of abuse of power, and that there is equality and non-discrimination before the law, because otherwise it's not really law, is it? And that there needs to be access to justice and a fair trial. You can see how this harkens back, the principles of the rule of law, harkens back to a question of human rights. And that's in fact because the principles of the rule of law are actually a little bit older than our Constitution, as you might well imagine. So going through these basic concepts, what is legality? Legality means the supremacy of the Constitution. I know it's a bit of a circular way of thinking about it, but it's the doctrine of legality that is an incident of law. It requires the exercise of public power by any branch to have enabling legislation or an enabling provision, be that in legislation or common law. And that all conduct must comply with the Constitution. There isn't really anything that can't comply with the Constitution, as we know. We need legal certainty. We need to understand what the law is. If there's no legal certainty, then it's very easy to say that you were complying, even if that's not what the law said, because it could be reasonably interpreted to mean three things. That's not what we need. Legal certainty also means that laws must be of general application. Now, I know that there are laws that aren't of general application, but the limitation on their application is reasonable. So, for example, there are certain laws that only apply to juristic persons, and certain laws that do not apply to juristic persons. There are laws that apply only to people in certain professions and not to everybody else. But this is when the limitation on the application of that law is reasonable and justifiable. The law there should be a rationale for why a law is made, and it should be fit for purpose. If there is a law, and the preamble says it is to ensure that every child has access to transport to be taken to and from school, but the content of that legislation also says that every truck driver crossing a border must be armed, then there's no rational connection between the law and its stated purpose. I'm being a bit flippant, that doesn't exist. Law should be clear and accessible, not vague or overbroad. Law needs to apply to who it applies to, and it must say so. I know that these are very, very obvious concepts. I just need to cover the bases, right? Law should be published. We should be able to access law. Now, I know that there is also this concept, this common misconception that everybody has access to the Government Gazette, but laws must be published in the Government Gazette unless there is a very good reason why not. It was very interesting during hard lockdown that new regulations and new provisions were created and published on different departments' websites, and apparently that was as good as legislation. It was only when there was a court challenge to certain provisions of the UIF TER scheme, because provisions had only been published on the website and not gazetted and therefore not enforceable, that the various ministerial departments started gazetting everything in earnest and in time. But we need to be able to find the law. It would lead to an abuse of power if the state could decide not to publish law and then just tell us that's what the law said and we couldn't find out. Think about these police states, these fascist states. These sort of principles of legal certainty keep us from becoming one of those. So law, in terms of public power, should also not give really wide discretion. And the executive needs really narrow discretion to implement and how to implement. Another thing that I think sometimes leads to certain questions is whether or not law should be retrospective. So if we decide today that something is illegal, let's call it possession of any pieces of silver. I'm just making this up. And it were to have retrospective application, that would mean that everybody who ever had pieces of silver would be guilty of an offense. Laws should be, because they need to be certain, they need to be accessible, they can't be retrospective. You can't be held to account for something that wasn't illegal 20 years ago when you did it. There are certain exceptions, of course. And law should not be arbitrary. It needs to be stated, it needs to be certain. These things kind of are circular, I know that, but they do need to be, I do need to mention them. Law needs to be there to avoid abuses of public power. Now, I know that in the last 2 years we have seen some abuses of public power that would make our heads spin another 2 years ago, but there have been abuses of public power, and our laws ought to safeguard us from it. But it's only us as sort of legal defenders of the Constitution who are able to ensure that abuses of public power are prevented. Okay, so in Affordable Medicines, Ngobo J said, as he was then, said, the exercise of all legislative powers is subject to at least two constitutional constraints. The first is that there must be a rational connection between the legislation and the achievement of the legitimate purpose. I'm not going to go into the rest of it, but that's really the ultimate crux of what he said. No, I am going to say the other. The other was that the constitutional constraints of the Bill of Rights is of paramount importance. So this is all in aid of avoiding abuses of public power. The next principle that I mentioned was equality before the law. So equality and non-discrimination. First, the law itself must comply with human rights. So this is human rights is generally accepted by international standards, being the Universal Declaration of Human Rights, as well as our own Bill of Rights, which is broader. And then secondly, the law requires democracy as an essential basis. We give voice to the powerful. It is our voice that the powerful use. So without democracy, we don't have equality. Again, as I said earlier, apartheid stripped people of equality. It was only a select few people who were voting for a select few people who were enacting legislation in their own interest. It was disgusting. So equality and non-discrimination before the law is of paramount importance to ensure that there aren't the other issues like lack of certainty, like abuses of public power. And then finally, in terms of legality, we need access to justice and fair trial. Now, access to justice is that anybody can have any dispute adjudicated by a judicial forum, whether it's the small claims court or the constitutional court. We all have a right to bring matters before court. When we are accused, specifically by the state, of transgressions of law, we have a right to being defended. We have a right to due process. There are rules that the prosecution needs to adhere to. And these, again, are limitations of public power, which is the number one principle of constitutionalism. I'm going to talk about administrative law now after this, because that is one of our biggest tools in our tool belt in terms of challenging public power that is arbitrary, irrational, and unreasonable.